I got something to say. They're not only ugly on the outside, but they're ugly on the inside.
Duane Keefe D. Davis, the man accused of one of the most infamous murders in recent history, spoke out during a court hearing Tuesday, accusing the government of tampering with evidence in the Tupac Shakur case. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. It's been a while since we've talked about Duane Keefe D. Davis, the notorious purported gang leader accused of ordering a hit on 90s rap superstar Tupac Shakur, who was gunned down in Las Vegas back in 1996. The 61-year-old was back in court this week to argue that he should be out of jail, on bail, on house arrest instead, as he awaits trial. Now, even though he is facing a charge of murder with the use of a deadly weapon and he has pleaded not guilty, he allegedly admitted his involvement in the killing in interviews and has claimed he was one of 4 people in a white Cadillac that pulled up to a BMW that Shakur was in when the gunshots rang out in Las Vegas. Now, Davis allegedly claimed that his nephew, Orlando Anderson, who's now deceased, was the one who actually shot the rapper, although there is reporting that Davis was the one who maybe provided the gun. Again, these are allegations at this point. But what we do know is that Davis has become the only person ever charged in the shooting of Tupac Shakur. He's being held in Clark County since his arrest last September, and now we've learned that prosecutors seem to have new evidence that they say proves Davis was in Las Vegas on the night of the killing. They say a hotel room was booked under Davis's wife's name. The state also says a witness, Corey Edwards, provided a statement to police in 2006 that he saw Davis with his own eyes out in Las Vegas that night. This was after the Mike Tyson fight. In a legal response, a footnote reads, quote, "Unlike many other witnesses who have provided corroboration of defendant's guilt, Mr. Edwards is still alive." Now, Davis's attorney has previously said that just because Davis says he was in Las Vegas doesn't mean he really was. One of the last times the issue of bail came up was back in June, when Davis explained that he could put up the $750,000 bond. Here's the problem with that. It seems Davis's team has pushed for someone in particular, someone in the hip-hop community, to put up $112,500 of the bond premium. Reportedly, this is coming from entertainment manager Cash Whack 100 Jones. And the judge in this case, Clark County District Court Judge Carly Kearney, had reservations about whether the source of this money was actually legitimate. So Davis's bond request was denied. You see, there have also been accusations that Jones agreed to put up the money in exchange for Davis agreeing to do a TV project. And one of the things that complicates that is apparently under Nevada law, convicted criminals are prohibited from profiting off of their crimes. We've seen this before, these kind of son of Sam laws, right? The defense seemed to counter that and say that a TV project or a documentary would be mostly about Davis's life, not just the Tupac Shakur shooting, and says that in no way does this break any laws, particularly since Davis isn't convicted yet. There's also been reporting that defense attorney Carl Arnold was receiving offers for a film crew to follow him as he works on Davis's case. He even allegedly called the killing of Shakur a legacy legal case. And that brings us back to that Nevada courtroom this week, as Mr. Arnold argued that the judge should reconsider her denial of bail.
On page 3, you said the purpose of the source hearing was to ensure the bond was not posted with proceeds from talking about the murder or killing of Tupac. There was no evidence at that source hearing that Mr. Davis was paid any proceeds for the murder of Tupac. He has been paid in the past through a book, through social media accounts, etc. The only evidence that we had at the source hearing was a prospective payment. And Mr. Jones was very adamant that there was no contract between those two yet. And so it was prospective in regards to his life story. The state made comments in regards to, well, the only thing that people would be interested in regards to his life story is basically in regards to Tupac, and that's simply not true. I mean, Mr. Palal has read the books as well as I have, his life story, he was one of the most notorious gang leaders of all of Southern California. He ruled Compton. He was the godfather of Compton. Basically, he had a drug trade that extended from here to New York to Little Rock, Arkansas. He was doing 350 kilos at a time with the Mexican cartel. There's many aspects of his life that are relevant and interesting to the community other than the death of Tupac Shakur.
A lot of my initial ruling really focused on the sufficiency of the documents and proof. Ultimately, this was not obtained through illegal sources. It was because the documents gave me so many questions about where those wire transfers came from, where those counter deposits came from. $50,000 deposited at accounters, and typical, what we're seeing. Additionally, when you go into his drug history and things like that. So we're really looking at, is this a bond that was posted through legitimate sources? And
right.
So that's why I was looking more into the bank records. And that's really the first part, the largest part of my ruling. I mean, I have concerns ultimately about the profiting off of Tupac's death, but I think my authority is somewhat limited in the source hearing to determining whether it's legal or illegal. Right.
At this point, since he's not convicted, you cannot tell Mr. Davis he cannot receive those monies. He can receive any monies in regards to this crime until he's convicted. That's well supported by the Nevada case law. It's supported by the statute that the state had previously alleged that they were relying upon, which was 41B200.
Which case law specifically?
No, they didn't mention any case law, but I'll get to the case law. But I was just saying that the state referred to 41B200.
Sure, the Slayer statute.
The Slayer statute, which says it has to be a convicted killer. Mr. Jones wanted a 10-part series. That 10-part series, I would imagine one of the episodes in that 10-part series would include the Shakur slaying, but there's many other things and interesting life events, crime stories, etc. that Mr. Davis can discuss. And so, do you see the distinction, Your Honor? The life story and just discussion in regards to Tupac Shakur.
I mean, I've read so many things, I don't know if they're true necessarily, but it seems like your end goal here is to make some sort of show on the prep for this trial, according to news articles that have been sent to me.
Like again, you read so many things about it. That's not my
quote to the Sun is not accurate.
That's not my end goal here, Your Honor. My end goal is to win the trial. Okay. Whether they want to follow me with cameras, they can do that. Are we going to benefit by that? I promise you, as an officer of the court, we have not signed a contract, nor have we been given any financial incentive to do something like that, Your Honor.
Okay. This case isn't going to be your legacy.
Hey everybody, I just want to take a quick second to thank Upside for sponsoring this episode of Sidebar. So Upside is a free app that gets you cash back on daily essentials like gas, groceries, dining. Now believe it or not, I do know how to pump my own gas. I don't know if that was controversial or not, but when I do, I can use the Upside app. Why not get cash back when you fill up your tank, right? And yes, this is actual, real cash back. No confusing rewards or points or credits, just actual money you can transfer straight to your bank account. So once you have the app, claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card, and you follow the steps on the app and you get paid. And as you just saw me do, you can use Upside at places like, Shell, Exxon, Mobil, 7-Eleven, Sunoco, restaurants like Chipotle, Papa John's, Dairy Queen, Domino's, KFC, Taco Bell. That's just to name a few. Now to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen and use our promo code SIDEBAR and get an extra 25 cents back on every gallon on your first tank of gas. That's promo code SIDEBAR for an extra 25 cents back on your first gallon of gas. The prosecution argued in response that even if you put aside the arguments about where these funds were coming from and what Davis would get in exchange, there's still the overarching concern that Davis could be a danger to the public.
The reason still remains true. Defendant's statement to his wife that Mr. Jones was a middleman, I think this court really has to consider. Also, as we provided exhibits, it wasn't just some spontaneous lie that he told his wife, as was proffered to this court at the last source hearing. Instead, these schemes, these plans, these attempts to deceive the court have been going on for months and months, laid out on jail calls over and over. Hey, we're going to use this person as a front. We'll use that person as a front. This person doesn't want to testify, so we've got to get somebody that will testify. And the sample I gave to the court is just that, a mere sample, a mere sprinkling of the scheming that has been going on by Mr. Davis in order to deceive this court as to where the source of the funds come from. And so, the other point I'd make is Mr. Jones lacks any credibility whatsoever based on the evidence that we've heard. Your Honor, I would go so far as to say that he perjured himself. And the reason why is, let's look at the evolution of Mr. Jones's positions. The letter he offered this court is, this is a gift. And I've known Mr. Davis for a long time. We're good friends for a long time. Then his testimony evolved. It started with when Mr. Arnold asked him, are you receiving any benefit? No, I'm not receiving any benefit. Then it goes, when I ask him, well, is there a contract? It evolves to, well, there's no contract yet. Then when Mr. Arnold asks him about, well, on the jail call, we did hear about a contract. Can you tell us about that? And then Mr. Jones tells an incredible story about what they're actually discussing. Has nothing to do with the murder of Mr. Shakur, but it's about a car that Mr. Davis once held, and he needs to get the title cleared. So that's what he's talking about signing. So, and then this court tried to clarify what Mr. Jones was saying, and Your Honor, you have the transcript. You tell me if you got anything from Mr. Jones's response, because I sure as heck couldn't figure it out. In fact, it's the reason why we asked for the transcript, is because, well, maybe I'm not understanding and something meaningful was said. No, it was just nonsensical rambling. And so that's just what happened in court under oath. Now we take the extra court, outside of court statements. We have a jail call that refers to a contract. We have a YouTube interview where he talks about stipulations. We have a Clubhouse interview, or a Clubhouse social media post, where he talks about, hey, I just received this contract, and as a result of this contract, I'm going to be bailing Mr. Jones out, or Mr. Davis out. And then after the hearing, he does another YouTube interview where he tacitly admits, yeah, so what if I got this from somebody else? What if I told somebody, hey man, I need $112,500 in order to make something happen, and you'll get it back if I can get that money back. That is a remarkable admission that he makes after this court hearing. And Your Honor, whether or not, and I'll address whether or not the legality of the court's requirement, but whether or not Mr. Davis or Mr. Jones agrees with the court's position, they are not allowed to, one, lie, attempt to deceive the court, or two, scheme on jail calls to circumvent this court's rulings. So I don't know what Mr. Jones could tell you that would give this court anything, prima facie, preponderance, anything, to believe that this is from a legitimate source, given Mr. Jones's observable willingness to deceive the court in order to get his deal done. So Mr. Jones has no credibility. Mr. Davis has no credibility when it comes to this, except though I do appreciate Mr. Arnold admitting, conceding that Mr. Davis is a notorious gang leader, that he was the godfather of Compton. I appreciate those admissions, but if anything, I think that should go to the later argument that Mr. Giacomo is going to present, that maybe this court ought to reconsider its positions, given these concessions today. Mr. Arnold's position has always been, you can't trust Mr. Davis because he's not telling the truth. Well, apparently he is telling the truth about being a godfather of Compton, and he is telling the truth about being a notorious gang leader. So, Your Honor, the source of the funds, at least for Mr. Jones, is just not credible. He is not a credible source. Anything that comes through him is not credible, is not reliable. And, Your Honor, I would argue that a person publicly availing himself of funds from the proceeds of a murder that is still awaiting trial is, in fact, putting the public in danger. After all, when we were here in January making this argument, one thing the state told the court and reminded the court is that the FBI literally had to move a witness based on credible threats from the defendant. Now we're going to infuse him with more funds from proceeds from killing Mr. Shakur. How does that keep the community safe? It certainly does not conform with this court's finding that a detention order was necessary to protect the community.
The prosecution also mentioned that it just received boxes of evidence related to the murder of Christopher Wallace, better known as the notorious B.I.G. or Biggie Smalls. Wallace, as you might remember, was shot to death in Los Angeles just 6 months after Tupac was killed. And that brings us now to talk about former LAPD detective Greg Kading, who wrote a book about the Tupac and Biggie murders back in 2011. He seemed to have all these investigative records at his home, but he says he turned over all the case files to Las Vegas PD this year after Davis was indicted, but he wanted to clarify that none of this material was obtained or kept by him illegally. Kading, in fact, told the court, quote, "I don't lose sleep over the fact that a confessed murderer is at odds with me for sharing information about his involvement in a murder." He goes on to say, "None of what he said reveals new information. It's well known. It was based on investigative resources from when I was at the LAPD." Mr. Davis, though, disagrees, because as this hearing was wrapping up, he, the defendant himself, stood up and spoke to the judge.
Can I say 30 more days and then make that
We'll do a
determination?
30-day status check then on trial readiness, and then
It'll be August 20th.
Now address the court.
I think we're done.
I got something to say.
You want to say to Mr. Arnold, and he can say if he represents you. So ultimately, you represent yourself. You can talk at will, but if somebody represents
Greg
you,
Kading had them boxes at his house for 15 years in his attic, doing all kind of TV interviews. That them boxes should not be allowed in a
he's
case.
just going to talk about it.
Yeah, them boxes should not be allowed. The tainted evidence, everything. The man, he broke a proffer agreement, and he broke the law, all kind of stuff. The boxes should not be allowed. He's been at his house for 15 years, and he's doing interviews, going in the boxes. Let me see here. Ooh, you can see it on any internet site that this man been going in the boxes for years, and he's on ethical, and a judge, federal judge in LA, did a 142-page thing about him. Look it up on the internet.
So I think what the state said ultimately is that they don't think there's going to be anything in those boxes that they're going to use. Is that
And
right?
you just used something in them boxes. They just used something in them boxes from 1996, and they know they did it.
Yeah, no, certainly we are.
They're not only ugly on the outside, but they're ugly on the inside. They crashed in my family in this. They did my daughter first. They did my son. Then they just did my wife the last year. What's the name? Told me about these. David Westbrook told me about these dudes. He said they're not only ugly on the outside, but they ugly on the inside too. These two dudes right here.
All right. At this point, there's nothing before me to exclude any sort of evidence. There's been no motion filed about the proffer. I don't know if Mr. Arnold plans on challenging that or not. Ultimately, that decision is up to him. So we'll see you guys back on that 30-day date.
That was August 20th at 9 a.m.
All right.
At that time, we need to know if we're going to go on the 3rd.
Thank you, Your Honor.
Thank you.
Now, Davis mentioned a proffer there. In fact, Davis had said this in his memoir, that he was given a proffer agreement in which he would tell police what he knew about Tupac and Biggie's killings in exchange for a lighter sentence on drug charges. In other words, what he says can't be used against him. But prosecutors have said it's not clear yet what information from that proffer would actually be admissible during his trial. Judge Kearney said that there were, quote, excellent arguments on both sides, and that she would issue a decision on the bail reconsideration in the next few days. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.